Assalamu alaikum and good afternoon, everyone. Once again, we are live with another session of Startup Summer School. Usman brings a wealth of experience in navigating the complex legal landscape and negotiating high stake deals, making him an invaluable asset for startups. Today, Usman will share his expertise on tackling legal challenges that startups face and mastering negotiation strategies to help you protect and grow your startup. Assalamu alaikum, Usman. Sir,
Ji,
over to you.
thank you so much, Hamza, for a very kind introduction. It's a pleasure to be here. The opportunity to speak with the budding entrepreneurs is always a matter of great honor. मोहम्मद उस्मान पिराचा जैसे हमजा ने मेरा इंट्रोडक्शन कराया I would like to talk about some things, but before I get into that, I'll just also expand on what Hamza was sharing, which is that I have obviously my own startup at NICAT. It's called Elegant Intelligence. And along with that, because I'm also a lawyer, so I practice privately. The name is Pirachas, which is the name of my law firm. And my work experience has taken me to three jurisdictions. Most recently, I was advising the Office of the Attorney General on some of the most complex disputes that our country, and at least for a good number of years, maybe even the entire legal industry has got to see. And prior to that, I was working in the US. I was working in some of the most renowned places like the Court of International Trade, and also the United Kingdom, where I worked at one of the largest law firms called Linklaters. And my academic background relates with a lot of you. Even though I am a lawyer, I must also share with you that I am an engineer as well. So my first degree was computer science. I am a computer science graduate from NUST. I have the idea about how fun it can be to code. And I say fun because for some of us, it's a great pastime, even, but for others, it's something we never get to really feel comfortable with. And then, of course, any startup knows that it's not just about the product, but it's also how you negotiate the legal landscape that is associated with your product, which is to become commercialized and also a success. And I will harken back ever so often to my experience at the University of Edinburgh, where I have a master's in management. So my experience at the business school and as a computer science expert is also going to connect with everything I say. And when I get to negotiation, I want to also touch upon quickly that I was the Caddy Award recipient, which means the only student who got the best um, overall grade in the aspect of negotiation in my school. And I graduated from an Ivy League school, so that was a matter of success. Now, if I look into what startups are like, and most of you are here because you have a great idea, you have a great team, but while you're invested completely in what you want and how you wish to pursue it, it is also important to not forget that at every stage of your evolution, you will have to keep a keen insight. You will have to keep a keen outlook for what needs to be done at that point in time. And I will explain that as we proceed. But to make it easier to understand at this stage, remember that for every startup, there is a necessity of taking a certain step while they're developing their product to ensure that they get to a certain outcome by the time they are ready to hit the market or otherwise have commercialized, right? And in that spirit, I will start with some of the things which will include talking about the type of entity that you should be as a startup. How do you present your startup as a business entity? Are you a single owner? Are you a public listed company, which of course you're not, and you will, inshallah, one day? But can people out in the public go and buy stocks of your company because it's listed on the Karachi Stock Exchange, for example? Otherwise, how do you manage contracts? How do you manage certain pitfalls, certain areas where you need to be cautious about when it comes to contracts, non-disclosure agreements, and most importantly, negotiation techniques. Because I think we underestimate the power of these soft skills when it comes to making good business decisions. So, negotiation techniques is also one of those things. And I will now get into the first area of discussion, which was the type of business entity. Now, I won't talk about each one of these because not every example is going to relate with your circumstance. But most of you, I would presume, and being somebody who was part of cohort 2 and uh, has gone through the entire process at NICAT, I can understand and I can make a presumption that sole proprietorship is where you are at this point in time, which means that you are an individual, or if a group of individuals, which would mean that you're a partnership, and you have brought together with yourself a certain business plan or a certain prototype, a certain demonstration of what you are willing to provide as a service, as your solution, your commercial product, which is perhaps in a stage of infancy, which is an idea or it is just at the initial stages of development. Now, the challenge with you as an entity, which is either a sole proprietorship, which means you alone as an individual are the one who is bearing the responsibility and holding the flag up high to take this company. And I'm using the word company as we use it colloquially, but I will call it a business entity from now on because company is something different, which we will get to. So you alone are somebody who's holding that flag up high for this business entity, which means that you're now a sole proprietor. And if it's you and some of your colleagues, then it means you are a partnership. Now, the problem with being a sole proprietor or a partnership is that if tomorrow somebody sues or files a case against your business entity, they will not only have the luxury of going after the assets of your business entity, but they can also come after your personal assets. So, for example, if your idea becomes a huge hit, your partnership, you and your colleagues create an idea, and that idea becomes extraordinarily successful. And that during a few months, years, maybe, you're able to commercialize your product. And unfortunately, it just happens to be that your product causes certain concern, damage, legal challenges in any client that you may have serviced, and they take you to court. And unfortunately, for whatever the circumstances we have in this hypothetical, the court decides against you. So the court says your client was inflicted harm, your client has suffered damage, and therefore, because of your product, you are liable to cover for their damages. Now, let's presume that these damages are some which can be catered for through monetary compensation, which means that you are now expected to pay whoever has suffered to cover for the damages that your product, at least in the eyes of the law, has caused. At this stage, your business entity has assets. But the law will not stop to your business entity. They will go after your assets not only as that which are under the accounts of your business entity, but also under your individual personal name. So this means that the assets of the business entity is not where the law will stop if they have to find monetary compensation for whatever damages have been caused. They will come after your personal assets. And then, like in the words of one of my law professors in London, who was explaining this concept to us many years ago when I was a student, his example was if you are a sole proprietorship or you are a partnership and things have gone south and the damages need to be compensated for, whoever needs to be compensated could eventually come after your personal assets, so much so that they will come after the buttons on your shirt. Now, that's a concern. But not to just talk about the pitfalls of what a sole proprietorship or a partnership is, there's also the benefit of having a sole proprietorship or a partnership, which is when it comes to divide profits, your profits are processed in such a way that you're not taxed twice. So it's not that the company is going to be taxed once and then your personal income is going to be taxed again. It's only going to be one iteration of taxes, which is where the company or you are going to be taxed in one go. And then you will get the revenue or whatever profit. In fact, I should say profit, whatever profit that you are now entitled to. But of course, what my suggestion is that keeping in mind the possibility of what is at stake, what the risks may be, my suggestion to startups will be that, and of course, it's very likely most of us are registered here in Pakistan or are planning to register ourselves in Pakistan, then the suggestion is that you sign up to either act as a single owner company or a limited liability company. And the way that you do this is you go to the SECP and you provide certain documents. You take whatever steps are necessary, you submit those documents, and now you are registered as a company. And that company would be a single owner company if it's only you and nobody else. Or it could be a limited liability company if it's private limited liability company if it is you and other colleagues of yours. And the benefit of doing this is that, coming back and hearkening to the example that I gave, if there was a case where the damages were to be awarded to a client that had suffered harm, those damages will not reach your personal accounts. So those damages will have to be compensated by whatever are under the umbrella of the company itself. The assets of the company will have to be used to cover the damages. If there are not enough assets of the company, then there's simply not enough monetary base to satisfy the damage. Even if your personal assets may be somewhere which is a multiple of whatever damages there may be, that is still outstanding. So essentially, whatever the damages that need to be settled are, your personal assets will remain safe. Your car, your house, your personal bank account, your shoes, everything that you own is not going to be up for grabs. Only what the company owns is going to cater for the damage. So you have a protection. You are separate as an entity from what the business is. If the business goes bankrupt, you will not go bankrupt. And the reason why the state does that is because it wants to encourage entrepreneurship. It wants people to go out and take risks so that they can do something good for the society by bringing their entrepreneurial spirit into the fabric of the nation, while, of course, offsetting whatever risks there may be. Of course, having said that, remember two things. You will be taxed twice. One is as a company, and the other is when you are personally earning from the company. And the second is that when it comes to a company and when it comes to an environment where you are operating as a company, you must also remember that where you have been taxed twice, the company itself is not going to protect you from any harm which could be due to fraud. If somebody goes around and starts doing fraud, which is a completely illegal activity, then the court will come after your personal assets. So the company and the umbrella that the company and the protection that the company provides you is not going to provide you that protection if the individual who owns or runs the company is part of what a court interprets is fraud. So only the kind of unintentional damages or damages that happen in the course of running a business is what a company is going to act like a shield for, not for fraudulent activities where the personal assets will fall under the bracket of what could be as a means to cover for whatever damages that have been caused. So I'll move further from here, but the takeaway here is this: register yourself as a company as soon as you're about to hit the market, as soon as you're about to sign contracts with potential investors, as soon as you have a beta version of your product, as soon as you're putting yourself out to get any risk involved, right? Register yourself at a company as at that point in time. That is my suggestion to make the entire discussion summarized in 3 sentences. Right, now moving towards the next slide. This is just going to be a very quick discussion, but when a company expands, there are different roles and responsibilities in the entire structure of that company. There are board of directors, there are shareholders, there is the management, and there are specialized committees that are engaged depending on what the circumstance may be. So, for example, when you have found, and inshallah, I hope this time comes for as many startups as is possible, and that there are many which are at the stage where the investors would want a board of directors, which is a group of individuals who can provide oversight on what the company's direction should be. They are like mentors, they are either paid or unpaid, and they are like a governing body to keep checks on how the company is to run. And those checks are, of course, going to be on the management of the company. And the thing is, these aspects are, of course, where you also have the possibility of having shareholders. And these shareholders are people who have either voting rights or can influence major decisions. But of course, as a startup level, you don't have to worry about most of these things. And we can therefore proceed to the next slide. Now, we come to contracts. And here is the thing about contracts that I have noticed, which is a matter of concern. First of all, taking our example of a group of individuals who have not signed up to present themselves as either a single owner company or as a limited liability company, a private company. And they are going around signing contracts at this stage. If you have not, and I'm quite sure most of you haven't at this time because you're very at the initial stages of this entire process. If you are signing contracts at this point in time and you register a company next year, whatever you sign today is not going to come under the ambit of the company. What you are signing today is in your personal capacity. So if any contract that you sign today results in a court dispute, and that dispute has to be settled by damages, and those damages are settled by monetary compensation, for the fact that these contracts were signed prior to the formation of the company means that the company is not going to be held liable, but you individually will be held liable, which means that your personal assets could be taken up to compensate for whatever damage that has been caused. Coming back to the buttons of the shirt, they will come after those buttons if they have to, because these contracts were not part of the company. However, the good news is that let's presume you are signing contracts these days, and 6 months down the line or 1 year from today, you do register yourself as a company. At this stage, you can come back, you can talk to whoever you signed the contracts with, and you can say, we now have a company. That wasn't the case last year when we signed these contracts. And therefore, we would like for these contracts to be signed with the company, not us as individuals. You as an individual could be a representation of the company. You as an individual could be the director, could be the CEO, could be the co-founder, but you are a director, CEO, or co-founder of a registered company. So essentially, you are the company agent. You've drawn the company's shield to protect you from any possible harm. Now, what you need to keep in mind, therefore, is that when you have this company and you are now trying to renegotiate either of those previous contracts, then you have to keep in mind that if you are signing those contracts today and you do not have a registered company, then make sure that in these contracts today, as of now, where you are a sole proprietor or either a partnership, you as an entity are the ones who are doing the business. You don't have a business, you don't have a company as such. keep a clause in those contracts that says, in the event that the signatories or whoever is signing the contract, the signatories means you, the individual who's signing, in the event that the signatories create a company, this contract shall be signed under the company name and will be allotted or granted in the company's ambit. Words to the effect. You can draft that clause either way you want. What essentially you're saying in this contract clause is that we will have this contract signed keeping the company as the signatory, right? So for now, that is what you need to keep in mind. Um, you will be surprised the number of times that I have talked to startups and individuals who have not read the contract. Even many lawyers, unfortunately, they haven't read contracts as well. When a contract turns up on your screen, we're just so used to pressing accept. And you install a software program, accept, accept, accept. There you go, right? Nobody understands what is written in there. We're so used to it. And then the next day, there's an investor who walks up and says, "Here is a contract," and we say, "Sign, sign, sign." All right, accept. There you go, without even reading what the contract says. You don't have to rely on the investor's interpretation of what the contract is. The investor is the one who is giving you the contract. And I will talk about those negotiation aspects in the next few slides. But it is the investor that is giving you that contract. So you have to be cautious because the investor is not an unbiased party. Whoever you're signing the contract with is not an unbiased party. The unbiased party will have to be a lawyer or somebody who can read the contract if you don't understand it and who can give you an impartial advice, right? Because they don't have to benefit from anything. They don't have to benefit from siding with the company with whatever the contract has to deal with, right? So try reading the contract yourself. If you don't understand the contract, talk to someone who can explain it to you. But don't rely on whoever has given you the contract because it's their contract and they're going to protect themselves in it, not protect you, right? I'm not suggesting that they're trying to cheat you, but I'm just saying that you need to get the best deal that you can.
Excuse me, sir.
Yes.
Sir, a few of the startups have been asking questions. So, will we be addressing questions at the end of the session, or should I show them on the screen side by side?
I think you can compile the questions. What I will try and do is once you have a list of questions, I'll try and answer some in such a way that we try and address as many as we can. But I
All
have a
right.
feeling that if there isn't enough time, that we will have to take this discussion for a time when I am either on site. I do drop by at NICAT. We, as part of cohort two, are
All
in
right.
the entire ecosystem.
So yes,
Uh,
we can actually deal with them as well.
we can
So
deal with
yes,
like
I'll compile them and we can actually address them at the end.
we could do that, or otherwise I'll leave my email address at the end and they can email me. But what we could do is try what we can address now, or otherwise take it
All right.
offline, right?
Yes, sir. Thank you.
Not a problem. So as I was saying, the pitfalls which are associated with contracts is not simply limited to the fact that it's not read, but there's also some basic areas where you need to keep a specific keen eye with regards to what you may be signing up for. So the typical pitfalls in a contract are timelines of payments. Many startups are not able to run because they don't have an extraordinary budget. If you are offsetting your payments at the end of the product, which means when the product is completed, which means another 3 years from today, which means you will have to bear those costs for those 3 years by yourself, then that is a decision that you need to think about. Because if your payments are going to be made once the product is completed, that means you are now personally liable to pay for your office, for your employees, for your electricity bills, for your computer, for your petrol, everything. So the timeline of payments, make sure you're happy with whatever timeline of payments there is, right? If you have a customer and the customer is providing for a service, looking for a service, those payments need to be in such a way that you as a startup are able to function during the time that you're able to give that product, so that you're able to work towards your product and have the financial strength to take you through that journey. Make sure you've clearly demarcated what deliverables there are. So my suggestion would be that you can say deliverable A, if deliverable A is completed, this is the payment that we can accept. If deliverable B is completed, this is the payment that we can accept. So you break it down with different stages and different levels of milestones that you are achieving and with which is associated your payment, right? Make sure. Now, before I get into dispute resolution, I must explain to you, you have to look at contracts as something which is in itself inherently, by the nature of its existence, a limited document. Now, what do I mean by that? There is no way under the sun that a contract will be able to cater for every possibility that there may be, which will or which could possibly result in a dispute. A contract cannot talk about all potential avenues that there may be that could result in a dispute, which you could discuss amongst your client, amongst your stakeholders, with whoever that you're signing this contract with, and come to some understanding and put it in a contract. A contract, therefore, is going to be limited. There are going to be avenues which you may not have covered in a contract, and those will have to be resolved. The manner of resolving any potential differences, disputes, unforeseen circumstances, so to speak, is via having proper dispute resolution scope protocols. And by that, what I mean is, how do you resolve disputes? Now, if we have a dispute, there is one opportunity, which is, let's take this dispute to court, right? Is that a good idea? Probably not. Because if you take a dispute to court, the very likely chance that you will be dragged in a process which is long and arduous and painful and expensive and gives you a lot of unnecessary stress is extremely high, right? So you might have some avenues in your contract which allows you to have alternative manners, avenues, possibilities of resolving your dispute. And what is that? Conciliation, mediation, or arbitration, right? So litigation is when you end up going to court. Anything you do other than that is part of an exercise that can help resolve those disputes before you drag yourself into a long drawn court battle. And conciliation, the way that you can understand what conciliation means is that conciliation is what, so for example, in our daily lives, we see our parents doing. When children, young children, when children are quarreling about something, when children have a bit of a fight amongst themselves because they're playing with, toys or something of that sort, the parents intervene and they solve the problem, right? They're not a legal authority, but they are a moral authority, clearly. And that is why the children listen to whatever the parent has to say to resolve the conflict, and they have the final word and the conflict is resolved, right? So in a way, it is a manner of resolving the conflict where the parties look towards somebody who has the authority. Mediation is like when children resolve the conflict amongst themselves. Think about it this way, that when children fight amongst themselves and one of the brothers and one of the sisters resolves the conflict, right? It's because both parties, all children, have respect for their sibling. They're on an equal footing, so to speak. But the mediation process is like when children resolve disputes amongst themselves. Arbitration, however, is where you have an expert. They don't have to be a judge. They could be a judge, but they could be an expert, somebody who is a CEO of a company and understands the nature of business. Somebody who is a PhD in lasers and optoelectronics and understands the nature of the product that you've made. some expert, either legal or otherwise, who will have the responsibility to resolve the dispute, but whatever decision that they make is going to be binding, legally binding. So you have to respect the decision of the arbitrator as if it was coming from a court. But the arbitration process is a much quicker process rather than going through a court. And it involves people who are experts, not just judges. So just for now, startups should just keep in mind that when you have a dispute resolution clause, make sure you have room to settle those disputes without either going, I personally think there's no need to go into litigation at all, or even arbitration. Hopefully, keep something which could cater for that circumstance. Keep something, say something like this. Both parties agree to resolve their disputes through conciliation or mediation, or you can specify whatever those circumstances are, from 60 days between when the dispute has arisen. So after 60 days, then we will go to arbitration unless both parties agree again to extend their discussions for another 60 days. So you give yourself some time to resolve that matter through conciliation and mediation in a certain amount of number of days or months or whatever. And if that is expired, then you have the luxury to extend it. And if you wish not to extend it, then you can take it to the arbitration, but don't go to arbitration at first stage. Now, which is very important to keep, because we as a society have this habit of taking things to court too early, which isn't always a good idea. So I talked about the ratification of pre-incorporation contracts, and now finally, authorized contracting agent. When I was a graduate of computer science, I remember working for a very large company, IT telecom space. And I came across eventualities where people were signing contracts, and though they were employed by this company, they were not authorized internally by the company to sign the contracts. Not every employee of a large multinational or whatever entity there is, or either a smaller one, not every employee who works in a company or a client with whoever that you're signing this contract with, or an entity that you're getting into a now business relationship with through this contract, is authorized internally to tie that business entity with you when it comes to signing a contract. This means they don't have the authority to sign on behalf of that party. So you have to make sure that you seek some sort of assurance or proof that you are the one, whoever is signing the contract as a client or whatever, the other party, whoever is the signatory on their contract, is authorized to make that signature. Because essentially they, as an individual, are tying the company with you under this contract. And if they are not authorized to tie the company, your client, this business entity, whatever it is that you are now getting into a business arrangement with through this contract, if they are not authorized, then you are in a problem. Not to suggest that if this happens that you don't have recourse to solutions. There are ways to get a solution through that. But why get into that trouble if you can actually avoid it, right? We will talk about non-disclosure agreements now. See, the thing why non-disclosure agreements are important is because at this stage, again, you being startups in a nascent stage of your progress, you have a business plan, you have an idea. You probably don't have the funds, or at least you don't have the luxury of spending whatever that resource you have, monetary in this example, to be invested in filing for patents. A patent basically is the means with which you protect your intellectual design solution, your any idea that can be commercialized could potentially be patented. But getting a patent in Pakistan does not mean you've got a patent in the US. Somebody could copy your design and sell it in the US, and you couldn't do anything about it unless you file a patent for it in the US as well. Which doesn't mean that they will now be protected in the UK, because then you'll have to file a patent in the UK also. So, with the patents, it's not simply a matter of cost, but it's also the fact that each jurisdiction has its own threshold for what is the necessary requirement which needs to be met for a patent to be successfully filed. Because not every patent that is pending is going to be patented. Not every request for patent is going to be accepted unless it meets certain criteria. And each jurisdiction, Pakistan, the US, the UK, in our example, will have different thresholds that need to be met for what is eligible to be patented. Therefore, notwithstanding simply the fact that it is going to be a costly affair, the better way to approach the challenge of protecting your intellectually unique idea is through signing non-disclosure agreements. Now, you could sign two different types of non-disclosure agreements, and I think they're both necessary. If you're a startup right now, you may or may not have employees. But if you do have an employee or employees, you need to make sure that when you sign a contract with them, you put in the confidentiality clause and the non-compete clause. So basically, you say confidentiality. Again, I'm going to make this really brief. Um, Confidentiality means that, listen, this idea that we're sharing with you and whatever the client is sharing with us as their requirements should not be shared with anybody else, because what the client is asking us to do is also unique. It's not simply our solution that we are giving the client, but even the requirements of the client itself need to be kept secret, right? So that's a way of ensuring that whatever is being shared with you remains within the confines of your business entity. And of course, you could expect your employees to also adhere to a non-compete clause, which means that if you would want your employee to not leave your company and set up something that rivals whatever product or service that you were getting or trying to provide, then they should be able to adhere to a non-compete clause, which, for example, could say, you as an employee are not to work in this space of providing such a IT solution for a period of 3 years. All right. So that's a non-compete clause. And of course, there could be other clauses as well, that you're supposed to keep information protected. You're supposed to keep information within the confines of the company. You're not supposed to share the information with anybody else. And all those details could be added into this employment contract that you sign with whoever you hire. But that's, of course, within your company. How about, say, if you're talking to an investor and you want to discuss a business idea with an investor? Now, my suggestion would be that first you explain to the investor that whatever is going to be discussed is going to be something that has to be kept confidential, and essentially we would need to be signing a non-disclosure agreement. And the investor is very likely going to say, I don't even know what the idea is. So you say, okay, we will share with you the idea. How about at this stage, first stage, we just sign a non-disclosure agreement and we say, without explaining the idea too much, but just a generic explanation, very generic explanation, we say that I will be sharing my idea about providing a certain AI solution for the legal industry with so and so, who is an angel investor interested in this discussion. And we will share this idea at our meeting tomorrow. And when you go to the meeting tomorrow and they've signed this initial non-disclosure, you share the idea, you explain to them the idea, and then you have a prepared document that has all the idea explained in text. And then you say, this is the idea that we've explained to you. This is the idea that you need to not disclose. And that is why we would now want you to know that this essentially is what needs to come under the non-disclosure agreement. You can make this one. You don't have to just split it in two parts where you first sign a generic non-disclosure and then you explain the idea and then you sign off on the idea in itself. But you can explain the idea and then you can put that idea in text when you get the final signature on the non-disclosure agreement. Essentially, you've asked whoever is being explained by you, whatever solution that you're giving, you have asked them to ensure that your means of approaching the solution, your unique solution, is kept confidential. And it has to be unique. You can't just generically say something which isn't specific enough and then expect an investor to sign a non-disclosure agreement. It has to be unique enough, right? Otherwise, you'll lose reputation. You don't want to be overly bureaucratic and overly difficult to work with. So it's a fine line to sort of balance there. But this is what is essentially the most cost-effective way to go about, which is sign non-disclosure agreements and make sure that you are therefore protected by competitors, essentially people who could take the idea and then maybe not give you credit for it. Now, this is the last slide, and perhaps although I mean, in order it comes right at the end, but I would say it's maybe the most important aspect that you need to keep in mind, because everything that I have talked about is something that you could not have foreseen. You could not have foreseen damages. You could not have foreseen the benefit of registering as a company. And hopefully you see it now. So that is, of course, anything which was prior to 43 minutes into our discussion. You could not foresee what the importance was for non-disclosure agreements. It's all those unknowns that you had to now, and hopefully you will keep in mind to ensure that you are protected against. But here is where you willingly end up negotiating a certain agreement, terms, contracts, arrangements that no law could actually come and protect you from, unless it is completely absurd, unless it's something like, you work for me for free and I will not pay you ever. Pakistani labor laws will say, what kind of an employment is this? I mean, okay, fine. If they were an intern for a few weeks, that's different. But you can't, quote unquote, hire somebody and ask them to work 9 to 9 and not get paid for another 5 years. Unless it's absurd, which the courts will strike down straight away, whatever is generally in the ambit of negotiation is quite broad. Those are terms that you may end up agreeing to, that you may just realize it's just the way that you worked, and it hasn't been the most beneficial way to operate as an entity, right? Something you willingly end up signing up for, and which does not fall into the realm of absurdity, and which does not fall into the realm of extraordinarily unfair or biased, is what you have willingly signed up for. And now you would be expected to adhere to it. So when it comes to negotiation, what percentage of your business? Okay, I am an investor. I like your idea. I'll give you this money and I take 50%. You've seen Shark Tank, right? And you say, no, you invest this money and I give you 15%. And then they pretend like it's absurd. Maybe, I don't know. I mean, who knows what the discussion was. But sometimes whatever has to be negotiated, and if you agree to 50 or you agree to 15, very likely you will have to adhere to whatever you've signed up for now, because neither of those falls into the realm of absurdity. It's something that you are willingly signing up for. Unless the amount was so low that nobody would expect 50% for, say, an investment of 2,000 rupees. But you get the idea. And now, what is important is that you have to manage this process of negotiation in such a way that, for example, again, harkening back to the example I gave, a negotiation may just start off with somebody who hands you a contract which is typed, which they prepared, not a third party, which they prepared. So they have set the scale where the discussion is going to start. So I walk into a shop. I say, what is the price of this cell phone? And they say, the price of this cell phone is 1 million rupees. Now, that is an extraordinary price. They've parked their price so high that even if I bring it down to 50%, it's half a million rupees, which is still very expensive for a cell phone. So sometimes they will start off their negotiation either through a written contract or otherwise face to face at such a scale which will psychologically put you as if, even if you ask for anything which is less than 50%, as if you're asking for too much. Even though the price of that cell phone may inherently be not more than a quarter of a million, asking them to knock 50% off from a million rupees would seem to you at the outset as if something that you've asked for too much. And they're playing into it because they've started off high, right? So be cautious about it. And don't be rushed to make a decision. Okay. So this cell phone is for 1 million. I'll give you a 20% discount. Nobody gives 20% discount. You pay the 800,000 now. However, if you fail to pay the 800,000 now, I'm sorry, we can't have a discussion. And if you come back to me tomorrow, it's back to 1 million. And now you're feeling the urgency of things, and you feel like, I can't lose the opportunity because I think it's expensive. I don't know if it is expensive, but I don't understand, and it's a lot of pressure. But I think if I say no, I'll probably regret it. So I'll just go ahead and say yes, and then the next day you're regretting it, right? So be cautious of all those techniques, um, and on the other side, make sure that you protect people's. I don't want to say ego as such, but a lot of individuals have quite a bit of an ego, which which could be a dangerous area to get into, because if they're feeling that their ego is being hurt by the way that you're negotiating, then they're going to be unreasonable because they feel that they're in a position of power and you're just a starter. It could be like that. So try and be courteous and respectful. You don't have to be needlessly absurd, aggressive. I don't think you need to be that anyway. I mean, if this deal doesn't work for you, it doesn't work for you. You can be respectful and you can just say, all right, fine, thank you for your time and good luck with whatever that you're looking for. And hopefully we will find somebody who has to invest as well. So there's no need to have bad blood, right? And at times, if you give people that respect, which is a golden bridge, you've built them a golden bridge with which they can go and retreat. You haven't broken all the bridges. You haven't destroyed the bridges. You've built them a bridge which they can take to go back wherever they started from. They may just end up taking it, which is they've taken back whatever position they had, which was 1 million for their cell phone. You've built them this bridge to get to retract from this absurd price quote that they gave without hurting their ego. And they've retracted now, and they're actually now willing to sell it to you for a quarter million rupees, which is where they know is a fair price as well. Right? So maybe they were testing you out as an individual. Let's see how this person reacts. That's also something that they do. They want to see how you operate under pressure. They want to see how you are as an individual. So you presented yourself as somebody who was fair-minded, who knew what the value of your product was or what the real price was. You were not rushed into judgment. You were respectful, and you were somebody who was keenly aware of the opportunity but were not willing to just fall for any of those traps. That is a pretty strong indication of what you are as an individual, while you may have a very sound business plan as well at the same time. And don't underestimate either of those, because there is no contract that is going to protect you from making a bad deal. Right? So now with that, I'll just quickly share with you that some of what I have talked about is discussed to some degree or maybe in greater detail on one of the seminars that I had the pleasure of being a part of. This was arranged by NICAT. If you go on YouTube and you search my name and you use the keywords business legalities, You should come to a link which I have shared, but of course, you don't need to remember that. Just click on whatever is, I'm going to presume, is the first result of that YouTube search, and you should find the seminar from last year, and it gives some insight into what we've discussed today, along with a few other things as well. So it's another useful means of furthering your understanding of whatever we've talked about. And of course, I have left my email address at the bottom. So with that, I'm afraid we don't have too much of time left, but with what we have in 9 minutes, we can address any questions that there are, and then we can take the rest offline. Thank you, Hamza. Thanks for your
Right, sir.
interest.
I'll now start posting questions one by one on the screen.
Mm.
Uh, First, we have.
I'd like to compress the questions if there is a possibility. So you can, if you can post all the questions, and I'll see if there is a way to address the idea, the general concern that there is in an all-encompassing manner, if it's a possibility, if that could be done. So if you could put all the questions up there, I'll take a minute or two, I'll read them, and then I'll start to address where there is a certain theme.
Actually, we cannot. Actually, the questions have been asked in the comment section, so we
Okay.
cannot post all of them side by side.
All right, go ahead. Not a problem. Not a problem. We'll just deal with whatever is there. Okay. Right. I think we have a question which says, how should a startup handle the legal aspects of hiring its first employee? Um, could you tell me what is stated? Yes, including employment, contracts, and compliance with labor laws. So I would say if you need a basic point to start with, um, look for whatever templates are out there generically in terms of the IT industry. So you don't have, again, your first employee could be an intern, and it may just be the case that you're not giving them a salary, and that's just what it is. It's a small experience where you're expecting a certain service, and in return of which you're trying to teach whoever is now part of your journey, but only for 2 or 3 months, right? So they said something about labor laws, and I'll say this again. I mean, this is the example that I gave. If now labor laws are obviously broad. There's a lot to be discussed under the sun when it comes to it. But if it falls into the realm of absurdity, it is going to get struck down, even if it's not in the labor law as such, because the courts will simply say this is just too out of the comfort zone. This is just too absurd. Generically, what I will say is, when you sign a contract with your employee, make sure you have the confidentiality agreement there. I think this question was very likely posted before I talked about those things on the slide. So I would think that some of those aspects that I talked about the slide were actually addressed prior, after which this question was posted. But whatever I talked about in those slides is something you need to keep in mind. And you need to make sure that you provide the basic level of protection in terms of workplace environment. Make sure about that. Make sure that the environment is such where they're not facing harassment, bullying, or any of those circumstances as well, because the responsibility will fall on you to ensure that the environment is one which is safe. And thank God for that we now have legislation where there are certain protections being extended to potential employees in the workplace. So keeping in mind all the discussion that I gave, if there are more specific things that you want to discuss, we can take that offline.
Sir, actually, we have a very good question from someone. She's asking that how can we address legal challenges internally between co-founders?
See, that's a very good question again. Now, there are there is a journey, I tell you. I mean, a lot of co-founders, when the going gets tough, that's the expression. That is where you test the metal about what you are as individuals, what this team is about, and anybody who's investing in your business is also gauging you as a team. How do you work as a team? So these internal challenges that you have, I would say, make sure you rely on conciliation and mediation as a means of resolving your dispute. Don't ever take the rash decision of, uh, suing your co-founder unless, of course, it has come to it. But I would say when you and your co-founder are agreeing on something to do as a startup, you as individuals can also sign a contract. It's perfectly fine. I know it sounds a bit strange. Oh, but we are best friends. We don't have to do it. You should. If it gives a certain level of protection to you as it does to your friend, so that neither of you are unfair to each other. And in that contract, you can explain what your responsibilities will be. So, for example, if I say my responsibility will be to talk and discuss this solution with clients and basically to take care of sales and marketing, whereas you, my co-founder, are going to be the one who provides the solution, the technical solution, then you've clearly identified what the roles are, right? And
Okay.
now you can, again, if this goes forward and you register yourself as a company, then you give yourself clear responsibilities and designations, while of course leaving the room to settle your disputes internally through mediation and conciliation. Right?
All right.
We
Sir,
still,
we have.
yeah.
Can we take just one last query, please?
No, I think we could maybe take two because we have another 3-4 minutes. So yeah, I just wanted to make sure that.
Someone from LinkedIn posted that if you can
Yeah.
double back on LLP because she missed it,
Sorry,
limited
the
liability partnership.
okay. So the limited liability partnership is somewhere between what a partnership, an unregistered partnership is, and what a limited liability company. So when I said an unregistered partnership is basically a group of people who are together, right? A bunch of friends who just come together and put a business plan up. Now that's a partnership. It's unregistered. You haven't actually gone and registered yourself as a partnership, but you're working together as partners and you're working towards finding a certain solution for the industry of with whichever that you're now part of. But eventually, what you're trying to do is basically work as a team, and you haven't registered yourself. I mean, we're all doing that, working in our basements, in our living rooms, working in co-op places. All of that is happening. We're working as partners, but we haven't registered ourselves as partners. Limited liability is company where you've registered yourself as a business entity, and now that's limited liability, and therefore you're now being treated as a company. Between these two extremes is what is called a limited liability partnership. Now, I can't exactly go into much detail about it, but think of limited liability partnership as somewhere between the first example that I gave of an unregistered partnership and the other explanation that I gave about a limited liability company. Between that, somewhere in the middle of both these alternatives is a limited liability partnership where you offset some of the liability onto the partnership, while as well also finding something like a middle ground as well. But of course, I mean, we can get into a further discussion. We can, but like you said, we'll take another question since we're almost out of time. And
Sir,
you
we
can,
have just this question about equity stakes, that how can a startup founder effectively negotiate equity stakes with early investors without losing the overall control of the company?
mm. So you know what, equity stakes, a lot of a lot of investors want the entire 51% at the first go. Why do I say 51 and why do I not say 49? Because 51% very likely means they will have the control of your company, which is going to be a bit of a problem. Because if you're starting off um, right at the outset, and you're going to hand over your business idea to somebody who has 51% stake, it could be a problem and you may not be happy about it. I'm not a huge fan of Hollywood movies, but there's this one scene in The Social Network, the movie about the Facebook, sorry. It's how Facebook comes together as an idea. Social Network, I believe, is the name. There's a scene in which the actor who's playing Mark Zuckerberg is sitting across Sean Parker, who is the, uh, the founder of Napster, and they're discussing how they can ensure that the equity doesn't get offset to the extent that the business ends up being run by somebody else and not by Mark Zuckerberg himself. So you need to have a step-by-step approach. You tell the equity, the person who has the equity, you tell them, well, and again, you build that golden bridge. You don't have to go out and say, what kind of a person are you? Have you never dealt fairly with anyone in your life? You don't have to go around and start making those accusations. Maybe they are giving you a huge $1 billion check and they want a 51% ownership. Go ahead and take it. But um, just build in that golden bridge and say, um, perhaps the possibility of 51 ownership could be one which we discuss, but we will have to have a step by step approach. What is it at the first stage you are willing to do which could earn you 10%? How much of what you are willing to help me with will earn that 10% for you? And once you've earned that 10%, then we'll talk about giving you 15%. After you've done something else which is more than what was worthy of your 10%. And then they have to earn in stages whatever equity that they're putting into your company and whatever stakes that are being now or shares that are being now offset to them under their ownership. So it's going to be a bit of a balancing act, but I always suggest you take steps. You divide it in steps. You don't just make one straight off the bat sort of an understanding or deal, and then you're thinking the next day that maybe you've made a discussion which was fruitless, or a decision like that. So um, we will now have to stop here, I'm afraid. It's been an absolute pleasure. Any further questions? As I said, I am on site at least once a week. You can expect me to be on site. If there are questions, we could perhaps discuss there. And then, of course, I look forward to assisting you as someone who has been part of the ecosystem. So I look forward to having a lot of you make great success and have a very enjoyable experience. And I've also shared with you my email address as well, because I understand not everyone who is online is going to be part of the ecosystem that we are in Rawalpindi. So for anyone who wishes to write me an email, my email is USMAN P for Pakistan IRACHA at P for Pakistan IRACHAS.com. Usman Piracha at pirachas.com. And Pirachas is my law firm. So that is where you can send me an email as well.
All right, thank you very much, sir, for your time. For all the startups whose questions could not be addressed in this session, you may ask them through email or through sir's website,
Yeah.
as you have been communicated earlier by Sir Usman Piracha. And stay tuned for more sessions. Thank you very much. Allah
My pleasure.
Hafiz.
Thank you, Hamza. Thank you. Take care.